resolve it that way.
What is next Thursday? That's
Should have their email.
4th? Okay, we'll set her for next Thursday,
Next
April
Thursday,
4th.
Judge.
Yeah.
Yes, Judge, thank you.
Okay.
Your Honor, Tim Gibbs on behalf of Brian Crocker. Judge, this is 24 CF 63, 23 CF 626, 23 CF 2360. Judge, we're trying to get Mr. Crocker into the Keaton program. We haven't officially gotten an acceptance from him, but we did last week get an email from them saying, wondering if Mr. Crocker was still interested. We, of course, responded that he is. He's also had his phone interview, Judge, with Keaton. I don't have the official acceptance today, so I'm reluctant to have him enter a plea to Keaton to do that just in case it
All
comes
right,
back.
I don't want to, let's make sure everything's lined up okay before we take any kind of plea.
And I'm very certain we'll have an answer next week.
What about April 4th?
Perfect, Judge.
Okay?
Perfect.
Yes, sir.
All right, thank you.
Thank you, Your Honor.
Okay.
We'll hound him for it. Your Honor, Tim Gibbs on behalf of Shannon Gallardo. Judge, this is 24 CF 545, 20 CF 128. I believe we have an agreement.
I give you the agreements, and this is the score sheet. Yeah.
All right, this is 20 CF 128, Shannon, State versus Shannon Gallardo. Mr. Gallardo, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
Thank you.
That's what you'd like to do? Please sign right there for me. Today's date.
28th.
Yes, sir. All right, you're good. All right. Your Honor, if I may approach.
All right.
Without objection, Your Honor.
All right, so Mr. Gallardo, you want to enter a nolo contendere plea and an admission of violation of probation. So in 24 CF 545, you want to enter a no contest plea to the charge of domestic violence battery. And in 20 CF 128, enter an admission that you violated probation, correct?
Yes, sir.
Okay. They're adjudicated on both these?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this admission in this no contest plea?
Yes, sir.
Anyone force you or threaten you to enter this no contest plea?
No, sir.
And admission of violation of probation? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission and no contest plea is freely and voluntarily entered. Court accepts it in 24 CF 545. Adjudicated guilty, sentenced 3 years probation, $100 cost of prosecution, standard court cost, $150 PD fee, no contact with the victim. In 20 CF 128, revoke and terminate probation, court's going to impose a new 3-year terms probation concurrent with 24 CF 545, $100 cost of prosecution, $100 PD fee, complete original requirements of probation. Adjudicated guilty.
Thank you, Judge.
Thank you.
Okay, thank you.
Thank you.
Yes.
Thank you. Your Honor, Tim Gibbs on behalf of Gravin Gamble. Judge, this is 23 CF 1540 and 13 CF 641. Your Honor, Mr. Gamble has filed a motion for a Nelson hearing.
All right, Mr. Gamble, tell me why you think Mr. Gibbs is being ineffective?
Yes, sir. Your Honor, my attorney failed to give me my motion of discovery in a timely manner as requested. It was not until the Nelson hearing was filed, then I received copies. I have been asking for these copies for about 3 months now. Also, my attorney failed to bring forth circumstances such as the fruit of a poisonous tree that I believe holds merit to these new cases and their outcome. I believe
A what across the street?
He said fruit of the poisonous tree,
fruit
Your Honor.
of a poisonous tree, excuse me, kind of said, that I believe holds merit to the cases and their outcome. I believe if it had not been for me being falsely arrested, that the current charges that I'm facing truly would have never happened, thus defining the fruit of a poisonous tree clause, Wong Song versus us. And excuse me, Your Honor, for my lack of education of the law, but due to my attorney's negligence, I was forced to study the law on my own.
You sound like you're very intelligent to me. What do you say about this discovery issue, Mr. Gibbs?
Your Honor,
I
we
mean,
did provide Mr. Gamble with his discovery packet after we filed our notice of discovery. He mentions the fruit of the poisonous tree issue, Judge. Originally,
that's a
So-
suppression type
it would
motion.
potentially be, Judge, one of the issues that came up. He was actually originally arrested, I believe, on a misdemeanor case. That's why he was in jail when this case happened, where he's alleged to have gotten into a fight with some of the COs. We have seen the video of that, and that misdemeanor case was dismissed ultimately. That's one of the things we're exploring as well, in terms of seeing if there's any merit to that as far as any defenses, any motions to suppress there. But we have given him discovery based, essentially, Judge, we do have a video. The state's made a new offer on his case for 72 months. It is a pretty substantial prison sentence as it stands, even though that does include dropping a couple charges if he were to enter a plea. Otherwise, we're preparing this for trial.
And you've given him all the discovery that you've received?
I believe I have, Judge, and if not, then we're certainly happy to send anything else over.
And you're in plea negotiations to try to get some type of...
We've been in plea negotiations. We've also done depositions of the COs that were involved, and I'm happy to provide those transcripts if the court
And
wants
how
that to
long
happen.
has he been in jail on these
I've
charges?
been in jail 9 months, sir.
9 months. What's his maximum type sentence he's looking for?
Judge, as charged, his maximum sentence, I'd have to pull his case back up, Judge.
Home invasion with a weapon is, that's like 30 years.
That's what he's on probation for, Judge.
Aggravated assault.
And then otherwise, the new case, he has battery in the jail, depriving the COs of their weapons, aggravated assault, resisting with violence, depriving an officer of...
When's he set for
protection.
trial?
I'm sorry?
When's he set for trial?
It's not set for trial yet, Judge. He's got pretrial on April 22nd. We were also supposed to have an evidentiary hearing this afternoon for the violation of probation, with the state, I believe, trying to go forward on the allegations for the new law violation that violated his probation. However, because we had this Nelson hearing, I don't know if the state canceled their subpoenas.
Yes, Your Honor, that's why I stood up to notify the court that this case was set for an VOP evidentiary hearing this afternoon, but after the defendant filed the motion for Nelson hearing, I canceled the subpoenas because we didn't know what was going to happen. I would ask that if judge denies the motion for Nelson hearing, that it be set for an evidentiary hearing on April 25th at 2 p.m.
Sounds to me like Mr. Gibbs is working diligently on your case. He's provided you with all the discovery. You might need to get up there and go over it with him, Mr. Gibbs. And but at this time, I'm going to deny the Nelson hearing because I know 9 months is long for you, but what you're potentially facing, he needs that kind of time to get prepared. And it sounds like you're about ready to have a hearing on April 25th. I don't know what's going to happen there. I haven't heard anything, but that might have a substantial impact on what you're looking at, one way or the other, beneficial to you or detrimental to you. I don't know, but sounds like to me Mr. Gibbs is being very effective, not ineffective.
Yes, sir.
Being very effective, not ineffective.
Yes, sir. Well, Your Honor, the original charge that I violated my probation for, it was dismissed in December.
Well, I mean, he's working on that too. It sounds like his office got it dismissed, didn't it?
We have discussed that, Judge.
Yeah. his office got those charges dismissed, which is now he's working on that dismissal to help you on this case, and he's.
Your Honor, that was a different attorney. That was a case that was in Fort Walton.
He had a case in Fort Walton, Judge, that violated his probation.
Public defender, right?
Yes, it was.
Well,
it was
y'all
one
are
of our
still
cases.
working together on it.
Yes, we do. We coordinate as much as we can.
All right, so I'm going to deny the Nelson hearing at this time. If I kicked him off, which I'm not going to, if I did, he'd be sitting in jail for months and months to get right back to this point with another attorney,
Sir.
okay? But, if something happens, you have every right to file another Nelson hearing that you feel that he's not effectively representing you. I'm not cutting you off from that. I can. I'm happy to hear it. But they've made substantial progress on your case. And whatever happens on April, it could have a real bearing to your benefit or detriment. I don't know. But Mr. Gibbs is very experienced. He's always been prepared in court. I understand your concerns, but sounds like he's preparing whatever motions to suppress or whatever it is. Is that right, Mr. Gibbs?
Yes, Judge, we've looked into him, and I'm happy to give it another look as well.
All right.
Your Honor, is there any way I can get a closer court date than April 25th?
No, that's the next one we have, except for April 4th. That's just next Thursday. That's not enough time. Because you got a VOP hearing in April. It was supposed to be this afternoon, I guess, right?
There was an evidentiary hearing scheduled for this afternoon, Judge, originally.
That might have violated your probation. But now it's going to be April 25th. This next court date we have. We'll hear it then.
So-
Okay, and
so-
maybe based on whatever you think that's going to happen there, it might really help you or hurt you. I mean, I don't know, but Mr. Gibbs will check into the bearing it might have on, a lot of times, I don't know, a lot of times a VOP causes a real benefit. If you work out your VOP, it causes a real benefit on your other charges, but I don't know. But you need an attorney to check into all that. You can't do it yourself, really, from sitting in jail.
So
Yes, sir.
is the court setting Mr. Gamble for April 25th for an evidentiary hearing?
Isn't that what you wanted?
Yes, Your Honor.
Yeah, April 20th. It's supposed to be this afternoon,
It was.
but y'all, because of what he wanted, they had to cancel their witnesses. I mean, you filed that motion. Now you could have had your hearing this afternoon. But because you filed that motion, that made the state have to cancel their witnesses.
Sir.
See, so before you even want to file a motion like that, you might want to talk to your attorney. Because they were ready to go this afternoon. You filed that motion, automatically, boom, that cancels the hearing, cancels their witnesses, got to reschedule it now. So you look,
He has been sending correspondence as well, Judge.
All right.
That we can review, that we will review and have.
and so we'll take a look at it April 25th.
Thank you, Judge.
All right, thank you. Yeah.
Thank you.
Next.
Your Honor, Tim Gibbs on behalf of Richard Glover. Judge, this is 22 CF 2131. Judge, I did not file a motion for a bond hearing. He's got a VOP right now for two bases. Essentially that he hasn't completed his substance abuse evaluation in his first year, and then he had a trespass charge out of Escambia County. I don't know what the status of that is. He's confident that that should be resolved or potentially even dismissed. We're trying to confirm that he actually has done his substance abuse evaluation. I kind of want to do I really, ultimately, Judge, I want to do an ora tennis motion for a bond. He does live locally. He would be able, if he was able to have $1,000 cash professional on this case, he'd be able to make that bond and be able to bond out. He does live locally. He would be in communication, and that would also allow him to resolve both cases, both his Escambia case as well as this VOP, simultaneously, potentially.
Well, what does the state say about that?
I object, Your Honor. I didn't have notice of a bond motion You can't just,
Well, what about April, set it for a bond hearing on April 4th?
We can come back next week, Judge.
How about that?
You wanna do
that's
that?
fine, Your Honor. I did have an offer that
Yes,
would
we've
release him.
We've discussed that offer. There also is an offer, Judge. The state is, the last offer that we discussed would maintain his withhold and reinstate his probation with the next year on community control. Because we believe that he has done the evaluation as required, and we're trying to get that proof, and we don't know what the status of that Escambia case is going to be, we're reluctant to enter any admissions right now, because in the event that both of those things resolve in his favor, we try to resolve this case in his favor as well.
Mr. Berry, did you want to say something about it?
Your Honor, if you can ask him for a minute, I can contact our office
Okay.
to see if he has done that evaluation.
About,
That's fine with me, Judge.
you want to, what do you say about that, Ms. Leon?
Well, there's still the issue of the other trespass charge that he has, so I would still,
Let's just bring him back April 4th, make sure.
Yeah, we'll get all that confirmed, Judge.
Because the state, you know, they need to have some kind of basis to agree, if they're going to agree to a bond.
Understood, Judge.
Okay, bring him back. We'll look at it, bring you back next week, April 4th.
Done next week.
Thank you.
Thank you, Judge. And I suppose for the record, since that was a VOP arraignment, we'll enter denial for the record.
Yes.
I think that's all of mine. Judge, for the record, on Michael Darrow, he's on both the morning and the afternoon docket. We just filed written pleas of not guilty for him. He's an inmate. He does not need to be transported.
All right.
Thank you, Judge.
Mr. Keach? All right, well, this is David Cornell.
Correct, Your Honor.
Okay.
He's here on the docket for his violation of probation cases, but he also has 2 new law violations, which we were also recently appointed on. I spoke with Mr. Cornell today, and it's my request to continue the VOP cases. No objection to them tracking with the new law violations. One of those cases is an attempted homicide. So I would ask to move it out potentially 2 months. And if we need to set a bond hearing, we can always do that in the interim, or 2 cycles, I guess.
that's fine. It should be set for pre-trial anyway, and
Right.
all can track together, all cases.
What about June 24th?
Is it okay moving everything to June 24th?
If you waive speedy trial, yes.
You want me to waive speedy, or you want to keep it? We'll just leave it on April 22nd. We won't waive speedy right now.
April 22nd, thank you.
Thank you, Judge. That's all I have. Maybe excuse? That's-
All right, Mr. Mr. Bo Powell, what you got?
Cheryl Vick,
Vic. Cheryl Ann Vic,
she's present. And this is
22
a-
CF 2561.
Judge, this was a PTI fail-out based on a letter of apology. We've resubmitted that to the state for them to review with PTI and with the victim in the case. And so we're asking to put this on the April 25th court date, anticipating a resolution.
All right, we'll see you on April 25th, okay? Thank you.
Thank you, Judge.
Do we have any hearings this afternoon?
We're not gonna have them, and, no.
Judge, the only other one that I have this afternoon is Ryan Bielik. Judge, we're either going to resolve that one, or I haven't filed a motion to continue, but I'm going to request a continuance because the state just gave us the video on the new law case on which the VOP is partly based.
All right, okay.
We'll still bring him, Judge.
Okay.
We'll bring him at 1:30.
We do have a couple of detention hearings, I believe.
We have 2, Your Honor, detention hearings. Yeah.
Waited on your new law, so we'll just continue it and I'll come see you.
Yeah,
Yes, Your Honor. Jennifer Flowers with the Office of Regional Conflict on behalf of David Anthony Fiducia. He's on today for two VOPs, 21 CF 667 and 21 CF 1433. He also has, I believe, two new law violations that were appointed to, so we would enter a denial for purposes of today and on the VOPs and ask to set this, I guess, on the next miscellaneous date. Or we could track with the new laws on April 22nd.
All right, April 22nd then. All right, thank you.
And this is Miss Sydney Hinesley. There's two cases on the docket, but there shouldn't be one. 23 CF 36 is closed, but 24 CF 276, we have entered into an agreement for a plea to PTI that we've previously gone over. I'm just going to have her execute.
All right, it's 23 CF 36, State versus Sydney Michelle Hinesley. Ms. Hinesley, would you please raise your right hand to be sworn? Do you swear the testimony you give for this court is true, so help you God?
Yes.
Okay.
And this is actually that case, the 36 case, 23 CF 36 is closed. She's entering a plea to PTI on 24 CF 276. And I have the plea. And PTI and score sheet.
All right, so she's entering a plea into PTI, is that correct?
That is correct, Your Honor, with the intention being if she successfully completes her PTI, that the charges will be dismissed. But if she does not, then it'll just come back for sentencing.
All right, so you want to enter a plea on count one to a lesser offense of fleeing and attempting to elude, a third-degree felony, and also plea straight up to reckless driving, count two, a misdemeanor, and resisting without violence, another misdemeanor. So you understand that?
Yes.
And if you fail to complete pretrial intervention, then you'll come back for sentencing because you're entering a no contest plea to these charges. You understand that? Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this no contest plea? Yes. Have you read the pretrial intervention agreement form?
Yes.
Do you want to enter the PTI program in hopes of having the case dismissed? Is there enforced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Flowers has done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it. Will not impose any sentence until we see how she does on the PTI program. Okay, thank you.
And Your Honor, for the record, Jennifer Flowers on behalf of Jennifer Wadsworth and 20 CF 1025. We reached an agreement with the state, just making sure everyone has signed. If I may approach.
Ms. Wadsworth, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes.
You want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, and possession of drug paraphernalia, a first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes. Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Ms. Flowers done for you on your case?
Yes, sir.
The state's going to dismiss a failure to appear.
It was never filed, Your Honor. We just agreed to take no action on it.
Okay. Court finds the plea is freely and voluntarily entered. Court accepts it. Sends you 75 days county jail or credit for time served, $615 court costs, $150 cost of defense, all monies to collections. Okay? Concurrent, adjudicated on both counts. Guilty. Thank you.
All right, thank you, Your Honor. I believe that's all I have on today's docket. I may be excused. Thank you.
You don't want to hang around and watch all these other lawyers?
Maybe.
Maybe? Okay. Who we got next? Yeah, call them.
Is it Marcus Ingram?
Is currently on supervision with us. If you'd like me to try to reach out.
What's he supposed to be here for?
He had to do community service work, and he was supposed to do it at a rate of 5 hours a month.
Well, he was noticed to be here, right?
Yes, sir. He was in court.
No bond capious.
Donald Griffin?
All right, what we got with Mr. Donald Griffin, this is 215 CF 289, violation of probation. What are we here for, Mr. Griffin?
Yes, Your Honor. The recommendation for probation would be revoke and terminate and incarceration.
How much?
I don't have the score sheet, Your Honor.
I was here for a plea day.
I know, she's just saying, if you,
Okay.
you're not, you don't have to take anything, if you don't,
Yeah.
they always just offer you a chance to plead if you want to. Is some kind of prison term or jail term?
And, Your Honor, I'm trying to find out, I have to pull up. You know, if we can pass it a second, I cannot
All
locate the
right, she
score
gonna,
sheet.
a lot of times what they do is they say, here's a chance for you to, if you want to take this deal, you can. You don't
But
have
the
to.
charges that has my probation violated is papers are in for it to be dropped, I thought.
She'll check into it. We'll take you back. We'll, don't worry, I'm not going, you're not going to have to plead to nothing if you don't feel like it, okay?
Yes, sir.
I'll tell you what, let me just, well, she may, just see what we got going here. And then I'll point you a public defender if you need help, okay?
Yes, sir.
All right, just have a seat. Thank you. Miss Rivers. Quinn, all right.
Your Honor, Michael Quinn's 24 on my docket, so it should be somewhat close on your docket. Your Honor, he's before the court on 24 CF 77. Your Honor, he has a case in county court down south, 24 MM 74, and a request for a mental health evaluation was filed and ordered. So at this time, we're just going to ask to continue this case until the outcome of that case. If we could put it on for maybe 4/22
All right,
and see if one's done by
April
then.
22nd. We'll bring you back and see how that's going, okay? Thank you.
And Spears.
Your Honor, this is Gregory Dwan Spears. He has two cases. One we're appointed to and one we're not. We're appointed to 12 CF 1224, which is like page 10, number 26 on the docket. And that's a violation of probation. And then for whatever reason, we're not appointed on his other violation of probation case, which is number 8 on the docket, 12 CF 1017. Are you requesting that I get appointed on both?
All right, I'll appoint him on both cases.
And Your
And,
Honor, we're going to enter a denial on both cases.
Okay.
And he has a new law violation allegedly, so we're going to ask that it all track together.
And this is Mr. Gregory Spears?
Yes, Your Honor.
Okay, thank you. Yeah, we'll do that. What day you want to say, April 25th for VOPs?
If we could just track with his new
That's
law.
fine. Yeah, April 25th.
Is that the date? That would be fine, Your Honor.
Okay, April 25th. Thank you, sir.
I'll come out when I got some more information. Okay? Your Honor, this is Carlton Tyus. He's before the court on 23 CF 214. We've reached an agreement in this matter, if I may approach.
All right. Mr. Tyus, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir, I do.
Thank you. State of Florida versus Antonio Carlton Tyus Jr., 23 CF 214. You want to enter a no contest plea to the charge of battery, a misdemeanor, and the state's agreeing to dismiss count 1 and 2?
Yes, Your Honor.
Okay. So you want to enter a plea to battery, and the state's going to drop the charges, count 1 and 2. You understand that?
I do, Your Honor.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, I do, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
She has been fantastic, sir.
Okay. Court finds the plea is freely and voluntarily entered. Court is going to adjudication withheld on count 3. Sentence you to 11 months, 29 days probation, waive cost of supervision, take anger management course, no contact with Terche Merritt. Court will reserve on restitution, no alcohol or drugs without written prescription, $676 court costs, $50 cost of prosecution, $50 PD fee, $50 app fee, no substance abuse evaluation, take a substance abuse evaluation, completing recommended counseling. And looks like she got 20 years worth of prison time thrown out, so that looks like you ought to be happy with that work.
Yes, Your Honor. I'm very, very happy.
All right, thank you, sir.
Thank you. Thank you, Ms. Glisson.
Okay, this is
Ready?
21 CF 2808, State versus Wilder, Velasquez, Carrera.
We've reached an agreement in this matter, Your Honor, if I may approach.
Mr. Velasquez, Carrera, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God? You want to enter a plea of, you want to admit that you violated probation, correct, sir? Did you read and sign this plea and sentencing agreement form? Are you aware of the rights you're waiving by entering this admission? Has anyone forced you or threatened you to enter this admission?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, Your Honor.
Are you happy with the work Ms. Rivers done for you on your case? Court finds admission freely and voluntarily entered. Court accepts it. Court's going to adjudicate you guilty, revoke and terminate community control, sentence you to, is it 60 months?
Yes, Your Honor.
DOC, credit for all time served, $100 cost of prosecution, $150 PD fee. How much time you got already served?
1 year of probation, Your Honor. Or, sorry,
No, how much jail time?
jail time. I want to say 7 months now, Your Honor.
Okay. All right, well, you'll be out rather quickly, so stay out of trouble, okay? All right, thank you. Yes.
Thank you so much.
All right. Christopher Lee Watson, 23 CF 2450.
We've reached an agreement in this matter, Your Honor, if I may approach.
All right, Mr. Watson, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God? You swear to tell the truth? Okay. This is State of Florida versus Christopher Lee Watson, 23 CF 2450. You want to enter a nolo contendory plea. And this is to count 1 and count 2, correct, Ms. Basso?
Yes, Your Honor, it is.
All right, count 1, unlawful sexual activity with certain minors, a second-degree felony, and count 2, unlawful use of two-way device and commission of felony, a third-degree felony. So you want to enter a no contest plea to those charges, correct?
Correct.
Did you read and sign this plea and sentencing agreement form?
Yes.
You understand the rights you're waiving by entering this plea?
Yes.
Has anyone forced you or threatened you to enter this plea?
Negative.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Negative.
Are you happy with the work Ms. Rivers done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge guilty on both counts, 10 years, sentence to 10 years, sex offender probation, no contact with victim, no unsupervised contact with minors, sex offender counseling and treatment, $150 PD fee, $100 cost of prosecution and standard court cost, sex offender designation. All right, probation, I guess, is better than, about 20 years in prison, so. All right, thank you. Don't violate.
Is he gonna be,
I'm sorry, the victim is over 16.
No.
request of supervision, please be waived?
All right.
And the probation is current?
Concurrent probation, yes. Concurrent probation on both counts. Although, wait,
It would have to be
I
5
can't,
years.
I'll have to do 5 years probation on count
Two.
2.
Yeah.
So the first one is 10 years probation, second one is 5 years concurrent probation, okay? All right, Bruce William Yarwood.
Your Honor, this is Mr. Yarwood. He's before the court on 21 CF 320 on violation of probation. At this time, we're going to enter a denial and request a date next month.
Okay. What about May 30th?
That
Or
would
you
be
talk
fine,
about
Your Honor.
April? About April 25th.
Okay, but May
Well-
30th is good too, Your Honor.
No objection, May 30th.
All right, May 30th, then we'll do that one.
I'll come talk to you. Yes, that's correct. Your Honor, I have, if I may, there's one. I think there's one other thing to address. Number 23 on the docket, Joshua Pellegrino,
Yeah.
18 CF 2983. You had already continued his companion case, 18 CF 2981, to May 30th. I think this just accidentally got left off. I'd ask that it be
All right,
continued as
continue till
well to May 30th.
May 30th.
I believe
What else? We got Mr. Powell out here. Mr. Powell, what case you got? Who? Come on up.
Take now approach.
Okay, yeah.
Miles.
Miles or Miley? Jason Robert okay. What y'all want?
Jason Robert Miles.
Is this on the record?
No.
He's on the list.
Only got about four or 5,000 of the cases, so it doesn't really matter. All right, the next case is Mr. Jason Robert Miles. Continue to May 30th.
Thank you.
Brooklyn Hagelin, okay.
Judge, on Ms. Hagelin, she's got a VOP that's scheduled for today, and then has a new law violation that's scheduled for April 25th. I'm going to enter denial on her behalf as to the VOP. I don't think the state's filed an information on the new law violation.
That's what you want to do, go to May 25th?
I would like to have them tracked together, so if we could bring the VOP file in on April 25th as well, that would be fine.
I did file an information, Your Honor, and I'm fine with that anyway.
All right, April 25th.
All right, Judge, thank you.
Thank you.
Can I have a copy of that?
No, ma'am. What I can, not today.
I noticed on the other paperwork that you handed me that somebody forged my signature.
Okay. All right, well, we'll look into that. I'm going to send somebody else to talk to you as well, and you can tell them about that as well, okay?
Your Honor, may I recall Mr. Donald Griffin, the one I said to?
All right. All right, Mr. Griffin.
Good. So, Your Honor, he violated probation because he committed a new law violation, and it's a domestic violence battery case. What I was asking Mr. Griffin is to plead to the new law misdemeanor battery, so lesser included, and then probation be reinstated with the original requirements. So no incarceration, basically.
You want to think about that? You want to do that? You want a public defender? Okay. Where's Mr. Griffin on the docket? I can't seem to locate him at this minute. All right, so what you're doing is offering Mr. Griffin, if he admits he violated So he's going to admit that he violated probation?
Yes.
And then it'll just be reinstated
Yes, with the original terms.
and adjudicated? He was already
Um,
adjudicated.
If, I don't know if he had an adjudication of, well, he is a convicted felon, so I would ask for, yeah, an adjudication.
All right, Mr. Griffin, you want to, they're offering, if you want to admit that you violated probation, you can just be placed, just continue out, finish up your probation. You want to do that? Would you please raise your right hand to be sworn? You swear the testimony you give for us, of course, the truth, so help you God? You want to admit that you violated probation? You wear the, you can put, you wear the rights you're waiving by entering this admission? Okay. Has anyone forced you or threatened you to enter this admission? Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? All right, court finds admission freely and voluntary hearing. Court accepts it. This court's going to adjudicate you guilty and put you just complete the original terms of probation. Okay?
Thank you, Your Honor.
All right, stay out of trouble, okay?
I will.
Thank you.
Oh, I see. Yes, thank you.
Hey, I want to sentence him to time served on the new law.
Judge, Mr. Howard has two cases. One is a violation of probation. The other one is a new law violation set for this afternoon. What I'd like to do is enter denial on the BOP and go ahead and arraign him on the case for this afternoon and have the two cases tracked.
All right, let me see what we got. All right, the new cases that I have are 24 CF 475, battery on a person 65 years of age or older, battery of an unoccupied, burglary of an unoccupied conveyance and possession of a controlled substance without a prescription.
That's correct, Judge. I have those under case number 24 CF 475.
All right, so court appoints public defender, and you want to enter a not guilty plea on that?
That's correct, Judge. Not guilty, 15 days pre-arraignment motions, and trial by jury.
Okay, we'll set him for, why don't we set him for, about, June 24th. If you get it resolved, we'll move him up.
Yes, sir.
Okay, thank you. Thank you, sir.
Thank you, Judge. All right, I'll come out and see you again.
Next one. David Wesley Johnson.
Okay, I'm probably going to have to. Judge, give me just 1 second.
How many more cases? How many more cases we got this morning? 8?
I have 1, 2, 3, 4, 5, 6, 7, 8 defendants, some of which will be pleas, most of them will be quick denials.
All right, because I wanted to take a break, but
Yes, sir. And then we've got pretrial detentions at 12:30, but I think those, at least mine's pretty well worked out, and the other one's kind of a moot point.
okay.
All right. Mr. Ma'am, the original offer was community control. He'll accept that. How long did you want him on?
2 years.
2 years? Yes, sir. I believe you wanted a...
I'm sorry, Your Honor, 1 second. Mr. Williams.
Yeah.
Thank you.
All righty. Yeah, it'll be 2 years now because you. Any special conditions or anything to go along with that?
I'm looking to see. No.
All right, we're going to take a 20-minute break. Thank you.
All rise, please.